Hi, hello everyone. Welcome back to my channel. We are back with the glossary of legal terms. The first term for today is appurtenance. An appurtenance is a right, privilege, or property that is attached to and passes with the ownership of a main property. Examples include easements, water rights, or a garage attached to a house. Appurtenance increase the usefulness or value of the principal property. They are considered a part of the land when sold or transferred. Its scope lies in property law and real estate. The next phrase is Kwashiorkor case law, health-related negligence law term. Kwashiorkor case law refers to legal cases dealing with a malnutrition, specifically negligence in preventing or treating protein deficiency diseases like a kwashiorkor. Such cases often arise when hospitals, schools, orphanages, or welfare institutions fail to provide adequate nutrition to children under their care. The legal principle involves duty of care, breach of that duty, and a liability for resulting harm. Courts may award damages or impose systemic reforms on negligent authorities. Its scope extends into public health care law and a welfare responsibility and a human rights in health care. The next term is secession. Secession is the act of a region, state, or group formally withdrawing from a political entity such as a federation or nation. It usually arises due to cultural, political, or economic conflicts. Secession raises questions of sovereignty, international recognition, and legality under constitutional frameworks. Some legal systems strictly prohibit it, while others recognize it under self-determination principles. Historically, secession has led to wars, treaties, and a creation of new states. The next phrase is legal representative. A legal representative is a person authorized to act on behalf of another in legal matters. They may be a lawyer, guardian, executor, or agent. The role includes representing interests in court, signing documents, and making binding decisions. The authority comes from law, appointment, or contractual agreement. They are bound by duties of loyalty and diligence. The next term is kuchari or kacheri, colonial legal administrative term. Kuchari was a term used during colonial India to describe a court or an office where administrative and judicial functions were carried out. It often referred to district headquarters where British officials, zamindars, or local magistrates conducted hearings. The kacheri served as a key point of colonial governance where revenue collection and dispute resolution took place. It symbolized both justice and control, blending judicial and revenue functions. Today, the word survives in some regions as a colloquial term for government offices or courts. The next term is apportionment. Apportionment is the distribution or division of rights, duties, or resources among parties according to established rules. In politics, it refers to dividing legislative seats among regions or states. In finance, it means allocating expenses or benefits among different accounts or stakeholders. Apportionment ensures fairness and proportionality. Its scope lies in taxation, corporate law, and a constitutional law. The next phrase is second appeal. A second appeal is a further stage of judicial review after the first appeal has been decided. It typically lies to a higher court, often on questions of law rather than facts. Its availability depends on the jurisdiction and the statutory provisions. It ensures deeper examination of potential errors made by lower courts. The process strengthens fairness but is restricted to prevent endless litigation. The next term is appraisal. An appraisal is an expert evaluation of the value of property, assets, or goods. It is commonly used in real estate, insurance, and business transactions. Appraisals guide sales, loans, and settlements by determining fair market value. Courts may also order appraisals in probate or divorce cases. Its scope lies in property law, finance, and commerce. The next term is rejoinder. A rejoinder is a defendant's reply to the plaintiff's replication in a legal proceeding. It continues the chain of pleadings and may include new facts or defenses. The purpose is to clarify the issues under dispute before trial. In some systems, rejoinders are limited to specific matters raised by the plaintiff. They ensure fairness by allowing both sides equal opportunity to respond. The next phrase is quasi-tort. A quasi-tort refers to wrongful acts that resemble torts but do not fit neatly into traditional tort categories. They arise where liability exists without a direct fault, often due to statutory provisions. Examples include strict liability or obligations arising out of duties created by law. Quasi-torts expand the boundaries of compensation and accountability. They represent the evolving nature of civil wrongs beyond a classical negligence or intentional harm. The next phrase is legal research. Legal research is the process of identifying and analyzing laws, precedents, and legal principles relevant to the case. It involves consulting statutes, case law, regulations, and scholarly writings. Lawyers and judges rely on it to support arguments and decisions. The quality of legal research affects the strength of legal reasoning. It is a foundational skill for legal practice and academic study. The next term is Kuri, in a cooperative banking law in India. A Kuri refers to a type of rotating savings and a credit association widely practiced in Kerala and some other Indian states. In this system, members contribute a fixed sum regularly and one member takes the pooled amount at each rotation, usually determined by bidding or lottery. It serves as a savings instrument, a credit mechanism, and a source of mutual financial support. In a cooperative banking law, Kuri is regulated to prevent a fraud and ensure fairness among participants. Its scope is both a financial inclusion and a community-based credit mobilization. The next phrase is arbitration agreement. An arbitration agreement is a contract in which parties agree to resolve disputes through arbitration rather than traditional court litigation. It ensures that an independent arbitrator or panel will make a binding decision on the matter. Such agreements are common in commercial contracts, employment contracts, and international trade. They help reduce congestion and provide a more confidential, speedy, and a flexible dispute resolution process. However, they may limit the parties' rights to appeal in a regular courts. The next phrase is quasi-transaction. A quasi-transaction refers to a legal relationship that resembles a transaction but it lacks the mutual agreement of parties. It often arises when the law imposes duties or obligations to prevent an unjust enrichment. For instance, restitution or recovery of money paid by mistake falls under quasi-transactions. They ensure fairness where no formal contract exists. The concept bridges gaps between strict contracts and equitable remedies. The next phrase is measure of damages. Measure of damages refers to the method used by courts to calculate monetary compensation owed to a party harmed by another's wrongful act. It may involve actual damages, consequential damages, punitive damages, or nominal damages depending on the case. The goal is to restore the injured party to the position they would have been in if the harm had not occurred. The measure varies between contract and a tort law. Its scope includes commercial disputes, negligence claims, and a breach of contract cases. The next term is arraignment. Arraignment is the formal stage in criminal proceedings where the accused is brought before the court to hear the charges against them. At this point, the defendant is informed of their rights and asked to enter a plea of guilty, not guilty, or no contest. It is a critical step that ensures the accused understands the allegations and the forthcoming trial process. Arraignment protects the constitutional right to due process. The procedure varies between legal systems but always marks the official start of the trial. The next phrase is legal responsibility. Legal responsibility refers to the obligation to act in accordance with the law and be accountable for violations. It arises from contracts, statutes, or general legal principles. Individuals, corporations, and even governments can bear legal responsibility. Breach of responsibility may result in liability, penalties, or punishment. This concept underpins both a civil and a criminal law. The next phrase is quasi-judicial review. Quasi-judicial review is the process by which administrative or regulatory bodies perform adjudicative functions similar to courts. These bodies examine evidence, hear arguments, and render binding decisions. While not strictly judicial, they must adhere to principles of natural justice. Courts may later review such decisions for legality, fairness, or jurisdictional overreach. This mechanism provides efficiency while maintaining oversight.